Hello everyone, welcome and thank you for joining us for today's session, Retail Sector Legal Update, Navigating Legal Change in 2025. Today is Tuesday 15th of July. I'm Sarah Cowan, a partner in the commercial property team here at Myerson, and I'm pleased to welcome you to this morning's webinar. Over the next 45 minutes or so, you'll be hearing from colleagues across our employment, insolvency, commercial and real estate teams, who will share key legal insights relevant to the retail sector as we move through 2025. We won't be running a live Q&A today. However, if you have any questions following the session, do feel free to get in touch with us directly. Our contact details are available on the slides that you'll see throughout the presentation. Now I'll hand over to Vicky Fagan, who is an associate in our employment team, to kick us off.
Thanks, Sarah. Good morning, everyone. Thank you very much again for joining us. So I'm going to be covering the first three topics that all employers in the retail sector should be aware of. The first topic relates to the current duty to prevent sexual harassment in the workplace. The second topic relates to updates in relation to harassment as proposed by the Employment Rights Bill. And the final topic that I'll be touching on are further developments relating to zero-hour contracts, also provided for in the bill. Starting off then with the current duty to prevent sexual harassment. So this is an anticipatory duty for all employers to take reasonable steps to prevent sexual harassment in the workplace. It came into effect on the 26th of October last year and ultimately is a positive and proactive duty to prevent harassment before it starts. Now, this is obviously important not only from a legal perspective, but also from a business point of view. Workplace sexual harassment can lead to various issues, including high-profile departure of senior management or other leaders, expensive litigation, damage to an employer's reputation, and damage to employee and customer relations, as well as issues with recruitment and retention. Now, the Equality and Human Rights Commission has provided various guidance in relation to this, and I've detailed some of those on the slide here for you. In particular, the 8-step guide makes it clear that the duty is more than simply just having a policy and undertaking perhaps one-off training. It makes it really clear that all employers should have clear, accessible policies defining what sexual harassment is and how employees can report it confidentially and safely. They should have regular and practical training, and in particular, this should be tailored to the retail environment that you operate in. And managers and supervisors should be trained to spot warning signs and also to be able to handle complaints properly. A speak-up culture will need to be created with managers leading by example, particularly given the younger and part-time staff who work in the retail sector, who might feel a little less comfortable in raising issues. And finally, a practice of acting fast, documenting matters, and considering what went wrong and what needs to change moving forwards is really key. In terms of enforcing the duty, there are two routes. So the first is for the individual who can make a claim of sexual harassment in the workplace at an employment tribunal. Where those claims are successful and the employment tribunal finds that the employer has actually failed in its duty to prevent sexual harassment, then the tribunal can uplift the compensation payable to that individual by up to 25%. Depending on the context and the extent to which the employer has failed in that duty. The second route for enforcement is through the Equality and Human Rights Commission, and the scope for enforcement there is actually wider. This is because the Commission takes a view that sexual harassment can happen at the workplace, not only at the hands of colleagues, but also at the hands of third parties, so your customers and suppliers, for example. And so the Commission has a wider outlook on compliance with the duty. Additionally, the Commission can get involved even when there's been no actual complaint of harassment or a claim being brought. And the Commission can take a view that the employer is actually failing in its duty and take enforcement action even when that claim hasn't been raised by the individual. The Commission's powers are really quite wide ranging, and they can conduct investigations into workplaces. They can seek agreement with employers around how they're going to address the problems in the workplace, and they can also agree action plans and intervene in litigation where necessary. Because of the delays that we're seeing in cases coming through the employment tribunals and subsequent appellant courts, we're unlikely, unfortunately, to get any guidance from tribunals about what reasonable steps might include anytime soon. That being said, it is helpful that the Equality and Human Rights Commission has already actually taken enforcement action in this area, and that gives us some insight into what reasonable steps an employer might take. I've put information on the slide here for you, and I won't go through this in any great detail, given some of it is the more obvious points surrounding training and education. But you can also see more stringent requirements, such as the review of the use of NDAs, non disclosure agreements, or confidentiality agreements. And also, you'll see there in the case of the Welsh Rugby Union, an equality, diversity, and inclusion strategy was to be implemented across the business with a 5-year plan, and with senior executives being required to have individual performance objectives to ensure that plan was reached. The Equality and Human Rights Commission enforcement to date hopefully reflects the fact that steps must be specific to the business and the industry in which the business operates. And tracking what the Commission is going to be doing or continues to do is going to really give us an insight as to what reasonable steps an employer is going to be required to take. So certainly something to keep on your radar. Moving to my next topic, but sticking with harassment, I'm going to give you an update in relation to the Employment Rights Bill and harassment as proposed within that bill. Now, as you'll be aware, the Employment Rights Bill promises one of the most wide-ranging overhauls of UK employment protections in decades. Now, the bill isn't law yet, and it's not anticipated that it will receive royal assent until later this year. But even when the bill is made into law, most of the changes provided are requiring regulations to be brought in to actually bring the effect of the provisions into force. And the majority of those are going to be shaped by significant consultations. So the first proposal that I want to mention is particularly in relation to sexual harassment in the workplace. And there are 2 amendments in the Employment Rights Bill that I want to make you aware of today. The first proposed amendment is that employers must not just take reasonable steps to prevent sexual harassment, but the employers must take all reasonable steps to prevent sexual harassment. Now, it's not anticipated that this duty will come into effect until October 2026, but I just want to make it clear that it is coming in. This certainly is the direction of travel. It's also anticipated that there'll be secondary legislation implemented in 2027 to specify what steps will be deemed reasonable in these circumstances. It is some time away, but it does seem that the Equality and Human Rights Commission is continuing to track this, continuing to provide guidance. So they're probably going to be your most helpful source of information in the meantime. The other change in the bill is, to the extent it's not already clear, that those who raise complaints of sexual harassment or support claims with such claims will have whistleblower status, and therefore they'll be protected from dismissal or detrimental treatment because they have made a report of sexual harassment. And that change is expected to come in April 2026. My last slide on this topic relates to third-party harassment. Now, some of you might recall that the original drafting of the Equality Act made employers liable for the harassment of workers by third parties. This was actually repealed in 2013, and the Labour government now are bringing that liability back into the legislation by way of the Employment Rights Bill, but with a little more bite. With this amendment, a single act of harassment may render an employer liable for that harassment. And in this case, harassment is on the grounds of any protected characteristic, not just sexual harassment that we've been speaking about previously. It's anticipated that this amendment will come in October 2026. However, the liability will not attach to an employer again where the employer has taken all reasonable steps to prevent that harassment. Despite October 2026 being a long time away, the direction of travel with this amendment has been clear from the outset. So I'd really encourage all retailers to think about what they can do to tackle harassment by customers, suppliers, and other third parties. This could be displaying zero tolerance signage in store, training staff on how to de escalate and report instances, and perhaps banning abusive customers, or escalating and reporting repeat offenders to the police in the case of a customer, or even to their own employers in the case of a client or supplier. The final topic that I'm going to very briefly mention are the proposed protections set out in the Employment Rights Bill for 0 hours workers, low hours workers, and since March 2025, agency workers. This is particularly relevant to the retail sector, but it's a really detailed area. And given the time constraints we have today, I've detailed more information on the slide as a bit of a prompt to anyone requiring information in this topic. So just to flag, one of the protections for such classes of workers is for the employer or the end user in an agency worker situation to offer guaranteed hours which reflect the hours that the qualifying workers or agency workers are actually working regularly over a defined reference period. If the worker rejects the offer, then the previous arrangements continue as they were, but the guaranteed hours regime means that the employer or end user is still obliged to keep making those offers at the end of each subsequent review period to ensure that they accurately reflect the hours being worked. If the worker accepts the offer of guaranteed hours, then this will create a permanent change to terms and conditions. Another form of protection, which I haven't particularly detailed on the slide, is also the right for reasonable notice of a shift and any change or cancelled shift. There's also going to be a duty on employers to make a payment to workers each time there's a change to shift at short notice. Now, all of this will be detailed in regulations, which unfortunately are still awaited. However, it's anticipated that a consultation in this area will open by autumn of this year, and hopefully we'll start to then see a little bit more detail as to how the new laws and new duties will work in practice. There are obviously going to be some situations where it's not practical or reasonable to expect an end user or employer to provide such guaranteed hours contracts. And there are some anticipated scenarios where that won't be the case. Again, I've detailed these on the slide here for you, but what I would flag is that they are subject to the initial consultation and subject to the regulations that will be brought in force in due course. And as with all matters, there is a risk of claims being brought if the regulations are not complied with or avoided, and the levels of compensation will be confirmed in the regulations. So wait and see is where we're at the moment. Now, given the level of detail to be included in the regulations and the fact that the consultation responses will need to be properly considered, it's not expected that any changes in this area will come into force until 2027. So there is no need for any immediate action. That being said, I've detailed some practical steps that employers can start thinking about in preparation for the changes coming in, including undertaking audits of the workforce, tracking seasonal fluctuations and demands in evidence, so you can use that for perhaps long-term, limited-term, contracts in the future. I hope you find that helpful, and it does bring me to the end of my topics today. I will now pass you over to my colleague, Vicky Biggs.
Thank you, Vicky. Good morning, everyone. My name is Vicky Biggs, and I'm a legal director in Myerson's Insolvency and Restructuring team. My part of the webinar today will cover how retail businesses can recognise and respond to financial distress. There is no doubt that the retail sector has faced difficult market conditions recently, with the latest statistics indicating a 19% increase in insolvencies in the sector in 2023 to 24 compared to the previous year. There have been a high number of high-profile insolvencies recently, such as Ted Baker and The Body Shop. There are several reasons why. Cautious consumer spending, given the ongoing cost of living crisis, higher interest rates, higher staffing costs due to increases in the national living wage and employer national insurance contributions, and higher business rates. There are a few warning signs which retailers should be aware of as follows. Firstly, cash flow issues. If a business is running low on cash daily and cannot pay debts when they become due, there is a risk that creditors will commence court action to recover what they are owed. Late payment of debts and/or an inability to meet liabilities can be an early indication that a retail business is in financial difficulty. 2. High levels of borrowing. If a company is operating at the limit of its overdraft and is having difficulties obtaining additional credit, this can be an indication that the business is in financial difficulty. Recently, retailers have specifically struggled due to higher interest rates, escalating their debt burdens, which is not being compensated for by increased sales revenue due to the cost of living crisis impacting consumer spending. 3. Falling profit margins due to high interest rates and increasing overheads. For a retail business to survive and prosper long term, it obviously needs strong profit margins. High sales revenue can be a misleading measure of business success if underlying business costs rise and profit margins are squeezed. 4. Poor financial record keeping. Maintaining up-to-date accounts are vital to ensuring a business has accurate information on its financial health. Bad financial record keeping can be a factor in failing to understand when the business is struggling and what could be done to help it. A notable factor in the downfall of Ted Baker was the discovery of a £58 million hole in its accounts due to stock value miscalculations. If you are a retail business facing any of the challenges set out above, there are a number of potential options and solutions which can be explored as follows. The first is preparing up-to-date management accounts to obtain an accurate picture of the company's finances. This includes considering the business's assets and liabilities, stock levels, and cash flow. The second is improving cash flow by renegotiating payment terms with creditors while the business tries to increase revenues. Thirdly, minimizing costs by, for example, finding cheaper suppliers or identifying more cost-effective premises from where the business can trade. With the rise of e-commerce and online shopping, many retail businesses have closed their physical stores and switched entirely to trading online to minimize business overheads. 4. Formal insolvency options, which include administration, company voluntary arrangements, CVAs, schemes of arrangement, restructuring plans under Part 26A of the Companies Act 2006, and creditors' voluntary liquidation. I will now provide a brief overview of each of these options. Administration is a process where a financially distressed company is placed under the control of an administrator, typically an insolvency practitioner. The administrator's role is to manage the company's affairs, business, and property to achieve one of three objectives. 1. Rescuing the company as a going concern. 2. Achieving a better result for creditors than a liquidation would. 3. Realising property to distribute to secured or preferential creditors. A company can enter administration either through a court order or, more commonly, via an out-of-court appointment by the company, its directors, or a qualifying floating charge holder. The administration process gives the company breathing space by imposing a statutory moratorium which protects it from creditor actions unless approved by the administrator or the court. This protection allows the administrator to either trade the company temporarily or prepare for a pre-packaged sale of the business and assets. A pre-packed sale is an arrangement agreed before the administration that is executed soon after the administrator's appointment. A pre-packed sale is only considered if rescuing the company as a going concern is not feasible. Administration typically lasts for 12 months but can be extended with creditor or court approval. Exit routes include liquidation, CVAs, restructuring plans, or early dissolution. A CVA is a flexible option for retailers, allowing them to reach an agreement with creditors over debt repayment, usually over an extended period of up to 5 years. CVAs often involve restructuring debts, reducing payments, or selling assets. For retailers, a CVA can help terminate or renegotiate leases for underperforming outlets, providing relief to struggling businesses. A CVA is initiated by a company's directors, an administrator, or a liquidator. The proposal must first be reviewed by a licensed insolvency practitioner, known as the nominee, who assesses whether the CVA has a reasonable chance of success. If approved by more than 75% of creditors in value, the CVA becomes binding on all unsecured creditors, even those who voted against it. However, one significant downside to a CVA is that secured creditors are only bound if they agree. Once approved, the nominee becomes the supervisor, overseeing the implementation of the CVA. A CVA can end either by successful completion of its terms or by termination if the company fails to comply, which can often lead to further insolvency proceedings. A scheme of arrangement is a more flexible restructuring tool often used in complex scenarios involving debt restructuring, mergers, or capital reductions. Schemes can be implemented early, even if the company is not insolvent, allowing businesses to address financial difficulties before they worsen. One advantage of schemes is that they are less publicised, reducing the risk of reputational damage. Schemes require approval by creditors, with at least 75% in value of each class of creditors voting in favour. The court is involved at several stages, making the process more expensive than other insolvency options. A significant benefit of schemes is the ability to bind dissenting secured creditors, unlike CVAs. While schemes do not offer automatic protection from creditor actions, courts may grant a stay of proceedings to allow time for the scheme to be implemented. Introduced in 2020, restructuring plans are similar to schemes of arrangement but offer additional features. Restructuring plans are specifically designed for companies facing serious financial difficulties that threaten their ability to continue operating as a going concern. Key differences between a scheme of arrangement and a restructuring plan include: restructuring plans require only a 75% majority in value of creditors for approval, without needing a majority in number. And they include a cross-class cram-down provision, allowing the court to bind dissenting creditor groups if the plan is approved by other classes of creditors with an economic interest in the company. Restructuring plans can be used by companies of all sizes, though the complexity and cost may deter smaller businesses from opting for this procedure. Large companies with more complex financial structures are more likely to benefit from restructuring plans. As a last resort, a company may opt for a creditor's voluntary liquidation, bringing its affairs and existence to an end. A CVL is initiated when a company cannot pay its debts and its liabilities exceed its assets. To begin the CVL process, the company's directors convene a shareholders meeting to pass a resolution to wind up the company. This resolution requires a 75% majority, after which creditors are invited to approve or nominate a liquidator. Once the liquidator is appointed, the company ceases trading and the liquidator takes control of the company's affairs, realising assets and distributing proceeds to creditors. The liquidator also investigates the company's affairs and the conduct of its directors, which can lead to claims of misfeasance or director disqualification. Unlike administration, there is no statutory moratorium in a CVL, though the court can grant a stay on legal proceedings if necessary. The liquidator's final report detailing the winding up process and asset distribution is filed with Companies House, and the company is automatically dissolved 3 months after the report's registration. All of the insolvency options I mentioned above will require the assistance of an insolvency practitioner. We have excellent working relationships with many national, regional, and local independent insolvency practitioners who can be called upon to provide their professional input and assistance as and when required. I hope this information this morning has been helpful. Thank you for your time.
Thanks very much, Vicky, and good morning, everyone. Thanks again for joining us today. My name is Olivia Whittaker, and I'm an associate in the commercial team here at Myerson. In this part of the webinar, I'll provide a brief overview of the Digital Markets Competition and Consumers Act 2024, which is a key piece of legislation for anyone who sells to consumers, and it was introduced earlier this year. So, what is the DMCCA? Came into force on the 1st of April 2025, and it presents a significant update to the UK's current consumer rights regime. I'm not going to explore the full remit of enhanced consumer rights that are available to consumers in the UK today, other than where they've been updated by the DMCCA, but it's worth noting that traders must still ensure that they're complying with these rights and obligations, including cancellation rights, returns, pre-contractual information, to name a few, especially as now there are much greater powers of recourse that are available to consumer who suffers a breach under the DMCCA. The main changes that were brought in by the DMCCA are twofold. Compliance, which is the previous unfair commercial practices regime, has been updated and brought under the remit of the DMCCA. And enforcement through the introduction of new enforcers who can bring enforcement action against traders via the courts, and the introduction of direct powers of enforcement for the CMA, which creates a new parallel route of enforcement to that of the courts. So, looking at these changes in a little more detail. On the compliance side, the DMCCA updates the unfair commercial practices regime, which sets out banned practices that are considered to be unfair in all circumstances. This regime is mostly very similar, save for some key changes that I'll go through today. It takes a simplified approach in respect of whether a commercial practice is likely to be unfair, which it will be if it's likely to cause the average consumer to take a transactional decision that the consumer would not have otherwise taken, as a result of the practice involving one of the following: misleading action, such as providing fake or deceptive information; misleading omissions, such as presenting info in a misleading fashion or omitting information; aggressive practices, such as harassment or undue influence; or contravention of the requirements of professional diligence, which is essentially going beyond what would be considered to be standard marketing practice in a given sector. This is a refocus in favour of the consumer, which moves away from the previous regime. We're no longer looking at whether the effect of the commercial practice was a material distortion of the economic behaviour of an average customer, but rather whether, due to this specific practice, did the consumer make a decision that it would not have otherwise made. One thing to note is that it appears the consumer doesn't have to have actually taken this decision, but only that these practices are likely to have caused a decision to be made or induced such a decision. There's a long list of prohibited practices which are considered unfair in all circumstances, which have remained largely the same, save for the treatment of consumer reviews. Some key examples of banned practices include bait and switch advertising, which is the advertising of one product with the intention of promoting a different product to the consumer when they follow a link or express an interest in the original product. Drip pricing, which is common in the transport and hospitality industries, where the total price ends up being much higher than advertised due to the addition of hidden but necessary extras. And the DMCCA's update around fake reviews includes the following banned practices: submitting or commissioning another person to submit or write a fake consumer review, or a review that conceals that it's been incentivized, which is a common issue with influencer advertising and led to the introduction of #ad. Publishing consumer reviews in a misleading way, or publishing consumer reviews without taking reasonable steps to prevent the publication of fake consumer reviews, false or misleading information, or removing such reviews from publication. And more new banned practices may be added to the list from time to time. And what are the repercussions if a practice is found to be unfair? Well, there are 3 key rights to be aware of for retailers, which the consumer can bring against a trader to enforce. And these are the right to unwind the contract if it's within 90 days of purchase, the right to a discount, or the right to reasonably foreseeable damages. And it's worth noting that the existing criminal offence regime does continue for unfair practices, and this can result in fines and imprisonment depending on the severity of the practice as well. The DMCCA also targets other discrete topics, and I'm not going to look at these in detail today, but these include subscription contracts, which are automatically recurring contracts for the supply of goods or services, which will change the pre-contract information requirements and presentation requirements that are applicable to such services. This is intended to come into force next year in spring 2026, and more information is expected on this. Consumer saving schemes, such as Christmas saving clubs, which are not currently covered by the Financial Services Compensation Scheme, but in the future, operators of these schemes will need to make sure that they protect the consumer payments against the business's insolvency through trust arrangements or insurance. And finally, the regime governing alternate dispute resolution, where updates include the requirement for any entity which offers consumer ADR services to have been accredited in accordance with the requirements of the DMCCA. So the biggest change that was introduced by the DMCCA is on the enforcement side. There are now 2 types of enforcers of consumer rights compliance. The first is public designated authorities, which include the CMA, the FCA, and the ICO, among others, and private designated enforcers, which currently only consists of the Consumers Association, but others can be added in the future. In general, enforcers can apply to courts to obtain an order to enforce certain actions or a monetary penalty against an infringer and or an accessory. And it's important to note that under this act, accessories do include company directors, so you can be liable for your company's actions. Enforcers, say for the CMA, should first engage in consultation with the infringing trader to stop the activity, to ensure the infringement doesn't take place, or to notify the trader that there may be a monetary penalty. Monetary penalties will be a fixed amount, and the maximum amount will not exceed £300,000, or if higher, 10% of the total value of the trader's turnover. This does include group turnover on a worldwide basis, and it mirrors the approach taken by the UK GDPR in respect of data breaches. There are also online interface orders, which would direct a trader in respect of online interfaces like websites or apps, and concern directions such as removing or modifying content, disabling or restricting access to users, and even deleting domain names or transferring the domain name to the enforcer. If an order is not complied with or an undertaking is breached, the trader may be liable for a consumer protection order or a monetary penalty. This penalty can be a lot higher, and the maximum amount would either be on a fixed amount basis of 150,000 or 5% of the total turnover, or on a daily rate basis of 15,000 or 5% of the total value of the daily turnover of the trader. And then separately to the court route above, the CMA also now has direct powers of enforcement. In short, without going via the court, the CMA can directly investigate suspected infringements, serve infringement notices and other notices, and levy monetary penalties at the same value as the court against traders. So, in practice, how has the DMCCA been enforced since its introduction? Guidance from the CMA, which was issued earlier this year, stressed that their objective was to help businesses to understand the conduct that's unacceptable and to know that their competitors are also playing by the same rules. The government has provided very strategic steers this year for the CMA in its role as regulator of the consumer sector. Some of these priorities include promoting consumer trust and confidence by deterring poor corporate practices, but at the same time by minimizing uncertainty for traders in providing proactive, transparent, and predictable engagement with businesses. As part of this, the CMA has published guidance for businesses which details its approach, including what businesses can expect from enforcement and its likely areas of focus, which include egregious practices where the law is clear, such as aggressive sales practices preying on consumers who are vulnerable, and providing objectively false information, and banned practices, including publishing or commissioning fake reviews, hiding fees until late in the purchase process, and including unbalanced contract terms, such as unfair exit charges on consumers trying to leave contracts. And it appears to have largely stuck with those areas of focus so far. The CMA commits to working with well-intentioned businesses and providing constructive advice to where the law has been updated or is less clear-cut. There's much more that can be said about this complex piece of legislation, but for the time being, I'll leave it there. We would always be happy to discuss any questions that you have about how it will affect your business or conduct a review or update to your existing consumer terms. Now is a great time to ensure that you're up to date and compliant. I'll now hand over to my colleague, Sarah.
Thanks, Olivia. So in this final section of the webinar, I'm going to be covering the High Street Rental Auction Scheme, and I'll also briefly touch on the current trends in retail leasing. The High Street Rental Auction Scheme was introduced by the government in December 2024 under the Levelling Up and Regeneration Act, or LURA 2023. The purpose of the scheme is to help revitalise vacant commercial properties on high streets and in town centres, and to allow local authorities to intervene when commercial properties have been left empty for an extended period by forcing a rental auction process. High street rental auctions reflect the government's commitment to tackling persistently high vacancy rates, which are currently at around 14% across UK high streets. Certain conditions must be met before a local authority can proceed with an auction of a vacant property. The property must be located on a high street or within a town centre that has been identified by the local authority as a priority zone for regeneration, and it must be suitable for high street use that would be beneficial to the local economy, society, or environment. High street use includes a variety of business types, including shops. The property must have been unoccupied for a continuous period of at least 12 months, or for a total of at least 366 days non-continuously within a rolling 24-month period. The local authority must also determine that the landlord hasn't taken reasonable steps to occupy, let, or market the property. High street rental auctions won't be suitable for all high street premises. For example, large former department stores may be subject to long-term and complex redevelopment plans and might be negatively impacted if included in the auction scheme. Premises which are affected by significant issues such as a dangerous structures notice or where they contain combustible cladding, for example, are also likely to be outside the scope of the scheme. So let's take a look at how the auction process works. The auction process begins with a 10 to 12-week notice period and then a 12-week auction period. Once the local authority has served an initial notice, the landlord will be given the opportunity to make their own arrangements to grant a lease, commencing within 8 weeks of service of the initial notice. This is the notice period. If the landlord doesn't enter into a lease agreement within that 8-week period, the local authority can then serve a final notice advising the landlord that it intends to run a high street rental auction in relation to the property. Assuming that final notice isn't withdrawn by the local authority following a landlord's counter notice or a successful appeal, then the process will then move to the auction period. After the notice period has passed, the local authority has a 12-week auction period to auction the premises and complete the lease or exchange an agreement for lease. During weeks 1 to 4 of the auction period, the landlord will be required to provide information about the property to the local authority. The auction pack will include the agreement for lease and lease, evidence of the landlord's title, replies to standard inquiries or CPSE, a full set of searches and other information such as the EPC, gas safety certificate, EICR and asbestos survey. During weeks 5 to 9, a marketing period follows where interested parties can register their bid. There's no minimum rental figure set out in the regulations, so tenants are free to submit a bid for any rental amount. However, tenants will only be able to bid once, and other bidders might outbid them. So it will be beneficial for tenants to submit a bid which they feel gives them the best probability of winning. In the final 2 weeks of the auction period, the local authority must serve the bids on the landlord before a successful bidder is chosen. And the auction period concludes when a contract is exchanged between the successful bidder and the landlord. If a landlord refuses to proceed for any reason, then the local authority has the power to step in and enter into the tenancy agreement on the landlord's behalf. At the beginning of the auction period, the local authority will have conducted a survey of the premises and produced a list of works that are to be carried out at the landlord's own cost. This is for the premises to reach what they call a minimum standard. The landlord must provide access to the local authority so that the survey can be carried out. If they fail to do so, the local authority can proceed to enter the premises without the landlord's consent. Minimum standard in this context means being in a safe and secure condition and with any significant occupational risks either removed or managed. Examples would include no significant water ingress or leaking, all internal and external doors operating safely, all external windows capable of ventilation or emergency escape, mains water, electric and gas connected, and toilet and hand washing facilities provided. The landlord must also ensure compliance with energy efficiency requirements and make sure that the property has a valid EPC rating. The landlord will have 3 months from exchange of the agreement for lease to carry out and complete the works. Should the landlord fail to carry out the works, the tenant will be able to rely on remedies set out in the tenancy agreement to ensure compliance so that the tenant can operate their business in the way intended when entering into the auction. Those remedies include the tenant carrying out the landlord's works itself at its own costs and then deducting the costs it's incurred from the rent payable under the lease. They also have the ability to terminate the tenancy agreement. And there are also liquidated damages, which are at a rate of £55 for each day that the landlord's works continue after the expiry of the initial 3-month period. Following completion of any required landlord's works, the lease will then be granted. The tenancy agreement itself will be in a standard form which has been specifically designed for the High Street Rental Auction Scheme. And some of the key provisions will include a term of between 1 and 5 years, a tenancy that is excluded from the Landlord and Tenant Act 1954. This means that any new tenancy would be at the discretion of the parties and does not have to replicate the terms of the auction tenancy. There'll be a fixed 4-week rent-free period for the tenant's fit-out works. Rent will be payable monthly in advance on the first day of each month. The tenant's repair obligations are limited to a schedule of condition. The tenant will have the ability to assign the whole of the lease with the landlord's consent, but all other dealings will be prohibited. And the tenant will be required to pay a rent deposit of the hire of 3 months' rent and £1,000. In terms of where the scheme is up to with implementation, there are now 11 councils that have committed to the process of implementing high street rental auctions. Given the 10 to 12-week notice period and then the subsequent 12-week auction timeline, to date, we're yet to see any significant auctions come into fruition. However, initial notices did begin in December 2024, and we expect to see the first active auctions take place this summer. The expansion from 3 to 11 participating councils in March this year is a strong indicator that this mechanism will become increasingly common across the country. So that was high street rental auctions in a nutshell. And to finish, I'll speak about some of the trends that we are seeing with retail leases. Traditionally, institutional landlords have favoured long-term market rent leases with frequent upwards-only rent reviews. But uncertainty in the economy has driven demand for flexibility in leasing. As a result, we're starting to see landlords being more creative in their dealings with potential tenants. Probably the most significant change in recent times is the dramatic shortening of the length of the contractual terms of retail leases, In the past, the average term might have been 10 years, and a term of 15 or even 20 years, especially for flagship stores, was not unheard of. Now the average term is 5 years, and we're regularly seeing terms as short as 2 or 3 years when tenant break rights are taken into account. We're also seeing the payment of bigger incentives by landlords, either by way of upfront payments or extended rent-free periods. Turnover rent arrangements began to appear more frequently in both traditional high street and shopping centre locations in around 2020 as a result of the COVID-19 pandemic. A turnover rent lease is a lease where the tenant pays a rent geared to a fixed percentage of the gross turnover at the leased property. Typically, the tenant will pay a discounted market rent as a base rent, usually around 80% of market rent. Over and above that base rent, the tenant will pay the turnover rent, being the amount by which an agreed fixed percentage of gross turnover exceeds the base rent. We also see some tenants negotiating terms where they only pay a turnover rent, which means that the rent payable is dependent solely on the turnover of the tenant's business from those premises. We did see this quite a bit in the immediate aftermath of the pandemic for obvious reasons, but generally these pure turnover-based rents are less common than the hybrid model involving a base rent. The main benefit for the tenant of a turnover rent lease is that the tenant pays a lower base rent, which eases pressures on cash flow during difficult trading periods or while they're working to establish a new business. Any turnover rent payable over and above the base rent is directly linked to the store's performance. Although landlords prefer leases with a fixed rental income, if the alternative is an empty property, then a turnover rent model will mean that the landlord will avoid paying business rates on an empty store, and they have the benefit of the tenant keeping the property in repair and paying insurance rent and service charge to the landlord under the lease. One of the obvious downsides for tenants is that in successful trading periods, they are likely to pay more rent than they would under a fixed market value rent lease. There will also be an increased administrative burden on both parties. The tenant has to report their turnover to the landlord, which can be complex, and the landlord will be responsible for calculating any turnover rent that's payable. Tenants should be aware that landlords are likely to want to restrict alienation of turnover rent leases because an incoming assignee or under tenant's business will have a different predicted turnover to that of the tenant. These restrictive alienation provisions will make assignment and underletting more difficult for the tenant. The landlord is also likely to require a keep open covenant in the lease. Tenants should ensure that there is a carve out for legitimate store closures, for example, during store refits or periods where the shop is closed for essential repairs or staff training. Overall, turnover rent leases can be beneficial to landlords and tenants. Both parties are invested in the success of the business being carried out at the property. If the business does well, the tenant benefits from higher turnover and the landlord benefits from higher rent. That's all from me and from us for today. Thank you for joining us. A recording of the webinar along with a copy of the slides will be emailed to you all shortly. And please feel free to share the webinar recording with colleagues or on social media. If you have any questions or you would like to suggest topics for future webinars, please don't hesitate to get in touch. As I said earlier, our contact details are on the slides. And thank you once again and enjoy the rest of your day.